One, the state must have the opportunity to act on behalf of consumers and protect them. That's just my observation of what I see here and what I thought I heard you saying.
Yeah, just waiting for my mic to turn on. Thank you. So, no, it's interesting because let's agree. We want the state to be able to ensure that consumer products are safe. You don't hear me saying otherwise. But I think it's actually quite fantastic that we could have, an inspector show up who doesn't know your business at all, finds that you're in non-compliance, may not even find a safety risk other than there's just a presumed risk for non-compliance, and could at that point just seize your property, could at that point write an order that if you don't comply with, every day is an offense. I mean, if they charge you criminally, every day is an offense with significant penalties, and okay, fine, a court's going to adjudicate that. But if they charge you administratively, even the issue of whether the order was properly made or made sense or, that is not an issue. It's just, did you comply with the order? And the fact that your property could be seized. Let's say an inspector comes to your premises and you're not compliant and you're not willing to be compliant and you disagree with them. And I mean, there are obstinate people out there. There are cooperative ones that are obstinate. I mean, right now, they have to involve the courts. They're going to charge you. They're going to get a warrant and seize your property, and the court's going to manage that. I'm not aware of circumstances where the existing rule of law isn't working. You see, that's what's confusing me with this bill. If this bill was written, if this was completely exigent and I couldn't get a telewarrant and I had to interfere right away, but, I've got 48 hours to report to a court, I'm less concerned. So you don't hear me saying that consumer safety isn't an important issue. You don't hear me saying that there isn't room to improve the legislation we have, but you have me saying, surely, to goodness, we can accomplish those legitimate goals in a way that involves the courts and involves the rule of law. You see, that's where I differ, is when I look at the objects of the Act, I don't see any reason why we can't actually have consumer safety and involve the courts. It's been working. I don't think all of a sudden now in 2009 consumer products are more risky than they were before. There's always been that danger. There's always been shady operators. There's always been fraud. We have a number of laws to protect that. But right now we charge people and we have the court supervise the seizure of property in it.
Okay.
Do you have a further question? Yes, go ahead.
Well, I've heard you. I don't agree with your interpretation. Indeed, my interpretation is that the individual or corporation or entity has the opportunity to respond to the issue raised. They have that opportunity. If they refuse to do that, presumably at some point they have to suffer the consequences of that. And finally, my reading of the law is that inspectors are, in fact, subject to the rule of law and have to justify their action under normal Canadian law. Thank you.
Okay.
We'll just have to disagree on that.
Yeah, all right.
So,
okay, let me move over to Senator Cordy, also from Nova Scotia.
Thank you very much. And as a non-lawyer, it's interesting to have the legal perspectives that you are both offering to us today. And I think when you look around the table, we are all interested in product safety. And the two of you mentioned that at the outset. And indeed, we would hope that the products that Canadians receive would be safe. It's not the reality, so we have to have legislation to hopefully make things better and for Canadians. Having said that, sometimes when legislation is drafted, there are unintended consequences. And I guess I look at this bill and I think that there are unintended, I hope they're unintended consequences. And Mr. Buckley, you talked about moving away from the law, and I guess what I think of is a person going to be found guilty not by a court of law, not by a judge, not by a jury, but by a minister of the Crown? And I have a few concerns about that. When I look at when I look at section 24, where the 20 bracket 4, where the inspector can enter, here we are, an inspector who is carrying out their functions or any person accompanying them may enter on or pass through or over private property. They are not liable for doing so. And then it goes in section 21, if the place mentioned in subsection 21 is a dwelling house, the inspector may not enter it without the consent of the occupant except under the authority of a warrant issued under subsection 2. Subsection 2 says a justice of the peace may give that warrant. Now, I'm not a lawyer, so is there a difference between getting a warrant from a justice of the peace and getting a warrant from a judge?
Good question. And actually, just so you're aware, most warrants are issued by justices of the peace. So even if you look at the criminal code provisions, which would be the search warrant provision South Canada currently uses, it is a justice of the peace. Now, if a justice of the peace isn't available, a judge can sit as a justice of the peace. So it's the norm for it to be a justice of the peace issuing warrants.
So it doesn't make, it's just the norm.
Yeah, so it's not a lower standard if that's what you were
wondering.
Thinking. No, it's not a lower standard.
Okay. I'm also wondering about disclosure of information by the minister. And we've had, and you made reference to it in sections 15, 16, and 17. And we've had businesses who are quite concerned that this disclosure of information by the minister may be disclosed not only to a person but to a government. And the definition of a government is not the Canadian government, but it's the government of Thailand or China or India or any other government. And they have great concerns about that. Is that an area where we should have, and not only is the information disclosed, but it can be done without the consent of the individual. So again, the individual is deemed to be guilty before any discussion whatsoever with the inspector.
Do you want me to? I'm just thinking my friend's probably better placed to answer that privacy question.
Well, in my experience, in the Customs Act and in the Special Import Measures Act, there are actually provisions that prevent government officials, including the minister, from disclosing sensitive customs information to third parties. They can share it internally with the government, but they cannot give the information to a competitor. They cannot give the information to someone that writes in for an access to information request, and they cannot give the information to a foreign government. So we have precedent in other pieces of legislation where information that's provided is kept confidential by the government. If you're giving the information in order to resolve a dispute or to communicate effectively and efficiently so that the right decision is made by a decision maker, it's not disclosed to other persons. And what if the shoe was on the other foot? What if it was a Canadian company and this was a piece of legislation that was passed in a foreign jurisdiction, and the Canadian company has patents or trademarks or some information that they really don't want their goods to be infringed, their intellectual property rights to be infringed in a foreign market? What would we be saying if it was a foreign jurisdiction that was having this legislation and a minister of, I'll pick on the Chinese, but I don't mean to, that a Chinese minister could hand this information over to a factory owner in China who is concerned about the quality of a Canadian good. What if? We wouldn't want that to happen if it was a foreign jurisdiction. Shouldn't there be checks and balances that someone's sensitive business information is not going to be shared, and it's not going to be shared to a foreign government because that can lead to all sorts of other complications. And what if we're wrong? What if there isn't a problem with respect to these goods and all of a sudden we've created a tempest in a teapot? Just because one individual didn't understand some of the business interests or some of the intellectual property rights interests, et cetera, because, an inspector can't know everything.
And because the information can be given without having any discussion with the person whatsoever. So you're right, perhaps it's misinformation.
Sorry.
Go ahead.
You finished? Oh, Senator Eaton wants to get in a quick supplementary. Quick.
Senator Cordy, what if the